Today we are going to discuss about prospectus and issue of securities. As you know, any company have following way of issue of securities. Either they can issue security by way of public offer, by way of bonus and right issue, and by way of private placement. In case of a public offer, the company can either go for IPO and FPO in case an IPO has already been raised. As far as private limited company is concerned, the private limited company has only two of the ways to raise the capital, that is by way of private placement and right and bonus issue. For public limited company, they have one additional way of raising the capital, that is by way of public issue. For this, they use a document which is called prospectus. So we'll discuss something about prospectus. There are basically four types of document which are described as prospectus in addition to main prospectus. One is red herring prospectus, second one is shelf prospectus, third one is abridged prospectus, and last one is any notice, circular or document issued in relation to offer for sale of securities of the company. That document will be deemed as a prospectus. So let us start with red herring prospectus. It's basically a document which lacks complete information about the price of the security. It is issued before the main prospectus is issued. This red herring prospectus needs to be filed with ROC 3 days before the issue of subscription. This red herring prospectus carries the same obligation and responsibilities as the main prospectus. Any variance between red herring prospectus and main prospectus needs to be highlighted. After the closure of offer, it needs to prescribe what is the amount raised by way of debt or share capital and what was the closing price, and any other particulars which were not mentioned in the red herring prospectus need to be intimated to ROC and SEBI. Okay. Now moving on to shelf prospectus. It is basically a prospectus issued by public financial institutions, PFIs, companies and banks. This instrument is issued so that each and every time whenever a company wants to make a fresh offer to public, separate document is not to be issued. So maximum validity of this document needs to be specified whenever this is issued. The validity cannot exceed 1 year. This shelf prospectus can be issued for one or class of securities. No separate prospectus is required for each and every offering. During the validity period of shelf prospectus, a company needs to issue an information memorandum describing the changes in financial particulars and other material particulars between the last issue and the current offerings. Information memorandum coupled with the shelf prospectus will be considered as a full prospectus. Now going forward towards the abridged prospectus, it is basically a summary of prospectus which is issued by the company in order to save the cost and give the information about the securities being offered in a summarized manner. Whenever any form is issued with relation to offer of sale of securities, then that form needs to be accompanied by abridged prospectus. It is the most cost effective way of distributing the information by the company to the prospective investors. However, in case there is an underwriting agreement or securities are not being offered to public, then abridged prospectus need not be issued. Lastly, any notice, circular, advertisement or other document issued with respect to inviting any offer from public, that will be deemed as a prospectus. Whenever the company offers, allots, agrees to allot securities to public, and any document issued with respect to this will be considered as a deemed prospectus only, and all the provisions relating to prospectus and all the liabilities relating to prospectus shall apply to this document as well. Now moving forward, what are the information is to be provided in the prospectus? Now it has been provided under Companies Law Section 26 that SEBI in consultation with central government will specify what financial parameters or information needs to be provided in prospectus along with such other information as may be prescribed. It goes on to state that before the issue of prospectus by the company or any proposed company, a copy of the same shall be delivered to the ROC duly signed by the director or proposed director of the company, and the same shall be issued to public within 90 days of filing with the ROC. Further, any statement in the prospectus by an expert can only be incorporated with the due permission of that expert only. Now with respect to variance in terms of contract and object in the prospectus, it is categorically not allowed except by way of special resolution passed in general meeting. The same has to be publicized by way of a newspaper advertisement, giving in one English newspaper and one vernacular newspaper in the city in which the registered office of the company is situated, along with the reason of such variation. However, the funds raised by the company from such public issue shall not be used in dealing with securities of any other listed company. And lastly, the dissenting shareholder shall be given an exit at the exit price by the promoter and existing shareholder of the company. Further, Section 28 is there which states that member of the company can authorize the company to offer their securities to public for sale. For that purpose, if any document is issued, that document will be considered as a deemed prospectus only, and such members are also required to submit to the company the cost in relation to offering of such security to public, and the company in turn will make all the arrangement for offering of such securities to public. Section 29 is there, which states that any public offer for securities of the company by way of IPO or FPO shall only be in dematerialized form or for any other class of company which may be specified. Further, any private company or any other public company is voluntarily authorized to keep their securities dematerialized form or convert their physical holding into demat form. Going further, if the company goes on to issue any advertisement with relation to prospectus, then in that case, that advertisement must contain the following particulars: the object clause of the company, the capital structure of the company, liability of the member, share capital of the company, signatories to the memorandum, number of shares subscribed by those signatories, and capital structure of the company. Section 39 is there, which talks about allotment of securities. It goes on to say that company shall not be authorized to issue any security unless the minimum amount stated in prospectus for subscription has not been realized by the company. Further, in case of a non-listed company, the amount realizable on application or application money cannot be less than 5% of the nominal value of the shares being offered, and in case of a listed company, the amount realizable on application money cannot be less than 25% of nominal value of the shares. Further, in case the minimum subscription has not been received by the company, then within 30 days from the close of the offer, the amount realized during the offer needs to be returned to all the applicants. Further, in case the allotments are being made, the company is supposed to file return of allotment by filing a form PAS3 within 30 days from the date of allotment. Lastly, the money to be returned will have to be in any form other than cash by way of valid banking channels. Section 24 is there, which talks about a regulator. Who will be the regulator? In case of a listed company, SEBI has been prescribed as a regulator. However, other than listed company, the central government is the regulator with regard to issue of securities. Then section 40 is there, which talks about that company need to have a prior permission from stock exchange on which they are proposing to list their security. The name of the stock exchange needs to be mentioned in the prospectus, and any application money realized by the company needs to be kept in a separate bank account, either for the purpose of return to the subscribers or for the purpose of adjustment against the allotment of the securities. Lastly, section 42 is there, which talks about private placement. It states that any offer to select group as specified board of director other than QIB and employees of the company, such number not exceeding 50, shall be considered as private placement. If the number exceeds the specified number or 50, then it will be considered as a public offer. Application money shall not be received in cash, and no such offer shall be made unless the previous such offer has been withdrawn by the company or has been fulfilled by the company. Any allotment, if it is to be made under this private placement, needs to be completed within 60 days from the last date of receipt of money, and if the money is to be returned, the same needs to be returned within 15 days along with the rate of interest of 12% per annum. Further, the company is not authorized to make any advertisement for private placement. Lastly, the return of allotment has to be filed with the ROC within 15 days of allotment. So friends, this was all about prospectus and issue of securities. I hope you would have liked the deliberation. This is Hemant Gupta signing off. Thank you for watching the video.